International law versus national sovereignty. The relationship between international law and national sovereignty stands as one of the most enduring and controversial dilemmas in modern global affairs. State sovereignty, particularly in the aftermath of World War II, remains a pivotal concept, yet it is increasingly challenged by the complex interplay of globalization and hypernationalism. International law, operating largely on the explicit or implied consent of sovereign states, strives to provide a cohesive legal order necessary for addressing collective global challenges such as human rights abuses, climate change, and transnational security. This video will argue that while international law inevitably clashes with the traditional, absolute definition of sovereignty, often exposing power asymmetries, it simultaneously provides the essential framework for cooperation, necessitating a modern reinterpretation of sovereignty focused on individual rights and state responsibility in an interconnected world. Sovereignty, fundamentally denoting independence, is defined as the right of a state to rule itself and those within its territory, to choose its own governmental and economic systems, and to exercise a territorial monopoly on the publicly sanctioned use of force. The modern understanding of this concept is historically rooted in the Peace of Westphalia in 1648, which established the state system based on principles of autonomy, territoriality, and the exclusion of external actors from domestic authority structures. Sovereignty operates on two interconnected levels: internal and external. Internal sovereignty refers to a state's ultimate authority, self-governance, and legislative competence over its citizens within its defined territory. External sovereignty relates to the state's equal position in the horizontal international legal hierarchy, implying independence outside its boundaries and emphasizing the principle of sovereign equality among all members. The core issue leading to the clash is historically located in the traditional view that a state's treatment of its own citizens was a matter exclusively within its domestic jurisdiction. The conflict is inherent because when states premise their claims to sovereignty on the idea that it is absolute, it implies that international law is not sovereign and that states are under no obligation to heed it. Conversely, the rise of international law requires states to be bound by rules and norms that restrict precisely this internal and external freedom. Although absolute sovereignty is seen by some contemporary legal doctrines as worn out or outdated, the principle itself, with its emotive overtones of unlimited power, remains paramount in political debates. The emergence of international law coincided with the growth of the geographically established sovereign state, necessitated by the need for standards governing interstate relations. This legal order is founded upon state consent, reflecting that no state can be bound to a rule of international law, other than jus cogens, without having consented, either through a treaty or the recognition of a customary norm. This exercise of the sovereign right to enter into agreements means that a state voluntarily limits its autonomy, or effectively chooses to become less sovereign. The modern expansion of international law significantly accelerated after the turning point of 1945, following the horrors of World War II and the foundation of the United Nations. The UN Charter fueled the relativization of sovereignty, opening the door for the internationalization of rights by stipulating the purpose of promoting respect for human rights and fundamental freedoms. Human rights were no longer considered essentially within the domestic jurisdiction of any state. International law crosses borders primarily through two sources: international conventions and customary international law. International conventions, treaties, are binding commitments that require signatories to amend domestic laws or abstain from certain actions, curtailing national autonomy. Customary international law is derived from a general practice accepted as law, opinio juris. Crucially, customary law challenges sovereignty because modern application sometimes assumes consent through acquiescence, passive acceptance, imposing obligations without explicit consent unless the state actively performs a persistent objection. This lack of explicit consent hinders a country's ability to govern itself autonomously. Furthermore, the focus of international law has expanded beyond merely state-to-state relations. 20th century developments brought the private party, the individual, directly into the international legal framework. Regional frameworks, such as the European Court of Human Rights, and global courts, such as the International Criminal Court, place clear limitations on the conduct of states, holding individuals accountable for actions taken under color of state authority. Thus, the development of international law has provided individuals with rights and protections that stand even against their own sovereign state. The conflict between international law and national sovereignty becomes most apparent in real-world crises or flashpoints. One major flashpoint occurs when gross violations of fundamental human rights are committed. Such violations, exemplified by genocide or apartheid, are conceptualized by some legal experts as state crimes or breaches of jus cogens, peremptory norms. In these cases, sovereignty is deemed no defense against international prosecution or intervention. The NATO action in Kosovo in 1999, which involved forceful countermeasures against Yugoslavia for mass human rights abuses, highlighted that sovereignty was not an insurmountable shield against reactions from the international community. Similarly, the 1994 UN-sanctioned intervention in Haiti, aimed at restoring democracy, demonstrated how human rights justifications can be used to breach the Westphalian principle of non-interference in domestic affairs. However, the efficacy of international law remains dependent on state power and consent. Powerful states often successfully reject effective external enforcement. In Dominguez v. USA, the Inter-American Commission on Human Rights ruled that the execution of juvenile offenders violated customary international law, yet the United States continued the practice, illustrating how the domestic rulings of powerful states can take precedence when explicit consent or binding enforcement mechanisms are lacking. Analyzing the modern tension reveals that the relationship between international law and sovereignty is often less a tightrope walk of mutual respect and more a reflection of international power dynamics, a power play. The existence of power asymmetries and the absence of a final authoritative decision maker consistently impede the development of stable international law. Consequently, the enforcement practice of international bodies often reflects the interests of powerful states, making powerless states vulnerable to sanctions. Sovereignty, therefore, continues to function as an effective political shield, often defeating claims of rights, especially when invoked by influential nations. Nevertheless, the relationship is also a pragmatic necessity. States utilize their sovereignty not to diminish it, but to gain something of value, such as security, trade benefits, or dispute settlement mechanisms, illustrating a functional tightrope walk. The proper exercise of sovereignty today involves using it to provide peace and security for citizens, which often requires participation in international agreements that limit state conduct. This tension is increasingly managed through the concept of shared sovereignty, where national actors voluntarily use their international legal sovereignty to compromise their Westphalian sovereignty. Arrangements like the European Union, where member states have ceded autonomy to supranational institutions, demonstrate that such institutional arrangements, while challenging traditional sovereignty, can endure if they create a self-enforcing equilibrium, meaning key actors believe they are better off adhering to the rule than violating it. Crucially, the conflict over sovereignty is increasingly being framed as a move away from the rigid Westphalian model toward popular sovereignty, rooted in the idea that governmental power is exercised by, for, and on behalf of the people. This shifts the focus from the absolute power of the state to the rights of the individual. In this modern interpretation, international law's challenge to state authority is justifiable when domestic governments fail to uphold fundamental rights, promoting a global order that values universal human protection above the unchecked autonomy of the state. The evolution of international relations necessitates a structural shift. away from the traditional concept of absolute sovereignty toward a nuanced understanding that accommodates global interconnectedness and responsibility. Future frontiers of international law must prioritize the rights and status of the individual, returning to the original focus of sovereignty as a concept defining the relationship between the person and the state. A useful approach involves embracing a flexible notion of sovereignty, understood not as an absolute attribute, but as the strength of a state's resolve to live by the laws to which it has agreed. This flexibility allows states to preserve their essential integrity while accommodating the more enlightened laws arising from the international system, thus preventing sovereignty from becoming an absolute shield against accountability, particularly regarding human rights abuses. Ultimately, the goal is not the demise of sovereignty, but its adaptation. Sovereignty and international order can realistically coexist. The proper exercise of sovereignty today demands that states proactively strengthen the international rule of law in order to enhance peace and security for their citizens. The future equilibrium requires that sovereignty remains a core principle of statehood, but evolves alongside international norms, ensuring it serves as a foundation for global cooperation rather than a barrier to global justice.